Yes, good morning and welcome to Legal Talk on E-Radio with Han and Han Attorneys. Today we are talking about face masks. Recently we finally got rid of them and now we can see the people's smiles again and see what color lipstick they're wearing. But what is the law saying about it? We are joined by Nirvana Pillay today. She is from Han and Han Attorneys, Associate Attorney, and she's going to give us a bit more insight into that. A very big hello to you, Nirvana.
Hello, Ian. How are you?
I'm great, thank you. How are you?
I'm well. Thank you so much for asking.
Cool. So, masks, let's talk about it. Finally, we're rid of it, thank goodness. But what impact has the lifting of the declaration of the national state of disaster had on the regulations imposed?
Well, the regulations and the directions pertaining to the declaration of the national state of disaster, it ceased to have legal effect on the expiry of the declaration. However, on the 24th of June 2022, the Minister of Employment and Labour issued a notice setting out the code of practice for the management of exposure to COVID-19 in the workplace, as there's still a threat of contracting COVID-19. This means that there still remains an ongoing need to prevent and mitigate the risks associated with the threat. Therefore, prudent for all employers, in terms of the Occupational Health and Safety Act, to provide and maintain, as far as reasonably practicable, a working environment that is safe and without risk, to take such steps to limit or mitigate the hazard or potential hazard. Now, in terms of the regulations for hazardous biological agents, COVID-19 is classified as a Group 3 hazardous biological agent. This presents a risk in respect of an agent that may cause severe human disease, which presents a serious hazard to exposed persons and which may present a risk of spreading to the community.
Nirvana, what is the purpose of this code of practice?
The purpose of the code of practice is to provide a guideline for employees and employees in managing their exposure to COVID-19 in the workplace. And this will include the conducting and updating a risk assessment in terms of the Occupational Health and Safety Act and the regulations for hazardous biological agents, as well as developing a plan to limit infection, transmission, and to mitigate the risk of serious illness or death on the basis of that risk. It also includes the implementing of the plan, managing the absence from work due to infection, isolation, and adverse effects of vaccination, as well as seeking to accommodate employees who refuse or fail to vaccinate against COVID-19.
And does the code of practice create an obligation on the part of the employer?
Well, despite the code setting out that the purpose is to provide a guideline for the management of exposure to COVID-19, it is clear from certain sections of the code of practice that it imposes a preemptory obligation on the employer. For instance, Section 1.5 of the Code of Practice states that the Occupational Health and Safety Act, with its regulations and incorporated standards, requires the employer to provide and maintain a working environment that is safe and without risk to the health of its workers. Section 1.7 requires that employees implement a special measure in order to prevent infection and transmission of the virus or mitigate the risk of serious illness or death. The employer is obliged to ensure that, as far as reasonably practicable, all persons who may be directly affected by the activities of the employer are not exposed to hazards to their health and safety. This includes customers, clients, workers, or contractors who enter the workplace or come into contact with employees.
Okay, and let's move on to the employers. What steps are the employers taking in order to mitigate the risk of exposure to COVID-19 in the workplace?
Well, employers have to undertake a risk assessment plan and to give effect to its obligations under the Occupational Health and Safety Act, as well as the regulations for hazardous biological agents. And then on this basis, develop or amend the existing plan. And this will include any measures to be taken in respect of vaccination of employees, any other protective measures contemplated in Section 6.1 and 6.2 of the Code of Practice. So Section 6.1 of the Code of Practice determines that the risk assessment and plan must include the following: identification of employees to be vaccinated, which also includes additional shots as well as the vaccine boosters, the reporting of symptoms by employees and isolation of employees who are diagnosed with COVID-19 and who are symptomatic, the workplace protective measures required to be taken in terms of the regulations, which also include personal protective equipment and ventilation, the procedure to resolve any issue that may arise from an employee's right to refuse to work in circumstances contemplated in Section 15.1 of the Code of Practice, as well as the process by which the obligation under this Code of Practice will be complied with. And then we have to look at Section 6.2 of the Code of Practice, which determines that the risk assessment plan may include the following: social distancing measures, including minimizing the number of workers in the workplace through rotation, staggered working hours, shift and remote working arrangements, personal protective equipment, personal hygiene measures, such as wearing of masks, barriers, hand washing, sanitizers and surface disinfectants, and any special measures to mitigate the risk of infection or serious illness or death in respect of an individual employee at increased risk, such as reducing the numbers in and the duration of occupancy of meetings.
Nirvana, may an employer simply implement the risk assessment and plan in the workplace, or are there other bodies and individuals that need to have sight of the risk assessment and plan prior to implementation?
Well, according to Section 5.1c of the Code of Practice, an employer must consult on the risk assessment plan with any representative trade union, as contemplated by Section 14.1 of the Labour Relations Act, as well as any health and safety committee established in terms of Section 19 of the Occupational Health and Safety Act, and in the absence of such committee, a health and safety representative designated in terms of Section 17.1 of the Occupational Health and Safety Act, or employee representative. The risk assessment plan must also be made available for inspection by the trade union, the committee, as well as the inspector.
This is a very interesting question. How will employers identify which employees are to be vaccinated?
Well, the Code of Practice is silent on how an employee should decide on which employee is to be vaccinated and which not. It would appear that this is the prerogative of the employer, taking into account its obligation to keep its employees safe. So in our view, the only employees that would not require vaccination would be employees who do not come into contact with other employees, or employees who do not come into contact with the employer's customers.
Okay. And what are the employers' obligations in terms of vaccinations of the employees?
Well, in terms of Section 12.1 of the Code of Practice, the employer must, in accordance with the measures contained in Section 5.1b1 of the Code of Practice, notify employees identified of their obligation to be vaccinated, counsel the employee of the issue relating to vaccines, permit the employee to take counsel from a health professional, safety representative, worker representative, or trade union official, give administrative support to employees regarding the registration for vaccinations, as well as giving employees paid time off to be vaccinated, and provide transport for the employee to and from their nearest vaccination site. However, in terms of Section 12.2 of the Code of Practice, the employee may require employees to disclose their vaccination status and to produce a vaccination certificate. We must also then look at Section 12.3 and 12.4 of the Code of Practice, which deals with employees who suffer an adverse effect resulting from vaccination, which renders the employee unable to work, as well as instances when the employee simply refuses to obtain the vaccination. It is to be noted that where an employee refuses to obtain the vaccination, then in that event, the employee is to take reasonable steps to accommodate the employee in a position that does not require the employee to be vaccinated. Section 12.6 also goes on to say that when an employee provides a medical certificate indicating that an employee has contraindications to vaccination, the employer may refer the employee to a medical evaluation for confirmation at the employer's expense. And where it is proven that an employee has contraindications to vaccination, then in that event, the employer must accommodate that employee in a position that does not require the employee to obtain the vaccination.
Nirvana, may an employee refuse to perform work if they feel that they are at serious risk of exposure to COVID-19?
Well, in terms of Section 15.1 of the Code of Practice, an employee may refuse to perform any work if circumstances arise which, with reasonable justification, appear to that employee or to a health and safety representative to pose an imminent and serious risk of their exposure to COVID-19. The section further deals with the manner in which the complaints are to be dealt with and the procedure to be followed in dealing with the complainant in terms of Section 15.1 of the Code of Practice. However, it is to be noted that an employee may not be threatened with an action as a result of exercising their rights in terms of Section 15.1 of the Code of Practice, or to be dismissed, disciplined, prejudiced, or harassed for refusing to perform any work as contemplated in the section.
Okay, and moving on now back to the employers, what measures are employers to be aware of in terms of the code of practice?
Well, employers must provide employees with information that raises awareness of the dangers of COVID-19, measures to prevent infection or limit infection, the symptoms associated with COVID-19, as well as the nature of the vaccines used in the country and their benefits, contraindications for vaccines, and the nature of risk of any serious side effects. In essence, all information pertaining to COVID-19, as well as vaccinations, are to be made readily available to employees. This can be done by placing leaflets and notices throughout the workplace, and where employees will have easy access to the information. Employees must also ensure that the workplace is properly ventilated by natural or mechanical means, identify areas with poor ventilation and improve thereon. This could be by merely keeping doors and windows open or through use of air conditioning and fans. The employers must also, upon being informed that an employee is experiencing COVID-19 symptoms, require the employee to be tested for COVID-19 before permitting an employee to enter the workplace or report to work. This will not apply when an employee reports the presence of symptoms between 1 to 3 days after vaccination. Should an employee be symptomatic, then in that event, an employer must place the employee on paid sick leave in terms of Section 22 of the Basic Conditions of Employment Act, or make application for an illness benefit in terms of Section 20 of the Unemployment Insurance Act, where the employee's sick leave has been exhausted. Should it become evident that an employee contracted COVID-19 in the course of employment, then the employer must lodge a claim for compensation in terms of the Compensation for Occupational Injuries and Disease Act.
Okay, and what are the key provisions that employers are to consider going forward?
Well, in consideration of the 6 sections of Code of Practice and the impact of the Code of Practice on the employers, the following obligations exist on the part of the employer. Employers are to update its risk assessment and plan to limit infection, transmission, and mitigate the risk of serious illness or death on the basis of that risk. Employees are to contemplate including the safety measures that are contemplated in Section 6.2 of the Code of Practice in the employee's risk assessment and plan. Employers must consult on the risk assessment and plan with any representative trade union as contemplated in Section 14.1 of the Labor Relations Act and Health and Safety Committee established in terms of Section 19 of the Occupational Health and Safety Act. And in the absence of such committee, a health and safety representative designated in terms of Section 71 of the aforementioned Act. The risk assessment and plan must be made available for inspection by the trade union and committee, as well as the inspector. Employers are to inform their employees of the Code of Practice, risk assessment and plan, and the manner in which the plan will be implemented in the workplace. Employees may, in terms of Section 12.2 of the Code of Practice, require employees to disclose their vaccination status and to produce a vaccination certificate.
What are the implications for clients and customers?
Well, Minister Joseph Fowler has made it clear that masks may still be required in private settings and requirements are still at the discretion of business owners and event organizers. The minister went on to say that if you run a facility, you have the right to determine regulations, whether you run a shop, a restaurant, a hotel, you have your own regulations and if you have your own regulations that you are comfortable with and your clients are happy with as well. The minister further added that this distinction applies to all individual entities, including schools. He noted that a school governing body may decide to keep its own mask mandate in place, and that this is distinct from government's own policies, and that government did not have a say in the decisions of individual entities. So there may be situations where customers or clients will be required to wear masks, where individual businesses have their own regulations in place that still require the use of masks.
Okay, so if I feel more comfortable let's say I have a shop, and I feel more comfortable that the people coming in, my customers, wear their masks, I can ask them to wear it?
Yes, you can.
Okay, and if they have a problem with it, what do I just show them the door or what?
Well, I don't think you can just show them the door. I think that you just need to make them aware of your policies in place within the business. And obviously, we can't control what other people do, but I think most people would respect individual businesses, regulations and policies that are in place.
Okay. Well, this has been very insightful, Nirvana. Thank you so much. That was Nirvana Pillay, Associate Attorney at Hahn & Hahn Attorneys. How do we get in touch with you, Nirvana?
Well, you can contact me on my email address at nirvana@hahnlaw.co.za, or you can call our office. Our number is, well, I can't find our number right now. Just hold on 1 second.
I'll give it. I've got it. I don't even work there, you know.
I've only been here for 8 months.
Perfect. No, it's fine. 012-431-2480. That's it.
Yes.
There we go, Nirvana. So if we can call you on that number, that's great. Thank you. That was very, very insightful. Thank you for your time today on Legal Talk.
All right. Thank you so much for having me on.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on E-Radio.